Dear students, I welcome you to yet another lecture on corporate law. The topic for today's lecture is the National Company Law Tribunal. In today's lecture, we shall understand the Constitution and various aspects relating to the functioning of the National Company Law Tribunal. The National Company Law Tribunal, also known as a tribunal, is a quasi-judicial body established to resolve corporate civil disputes under the Companies Act of 2013. It is endowed with the same powers and procedures as a court of law. Dear students, we shall now try to understand the genesis of the National Company Law Tribunal. The Government of India constituted a high-level committee in 1999 under the chairmanship of Justice V. Balakrishna Iradi to examine the existing laws on insolvency of companies and winding up procedures and suggest reforms to avoid delay. The company inter alia identified multiplicity of court proceedings as the most significant reason for critical delay in the dissolution of companies. In line with the laws on corporate insolvency prevailing in industrially advanced countries, the committee recommended the constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal, combining the powers of the Company Law Board under the Companies Act, the Board for Industrial and Financial Reconstruction, and the Appellate Authority for Industrial and Financial Reconstruction under the Sikh Industrial Companies Special Provisions Act 1985, and the jurisdiction and the powers relating to winding up presently vested in the High Court. Pursuant to the recommendations of the committee, the Company Second Amendment Act 2002 was enacted to introduce Parts 1B and 1C in the Companies Act, providing for the establishment of the NCLT and the NCLAT. The implementation of the 2002 Amendment Act was stalled on account of a writ petition filed in Madras High Court by Sri R. Gandhi, the President of the Madras Bar Association. The petition challenged the constitutional validity of Chapters 1B and 1C of the Companies Act 1956, inserted by the Amendment Act, providing for the constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal. The Madras High Court, by its order dated March 30, 2004, held that the establishment of the NCLT and the NCLAT and vesting in them the powers hitherto exercised by the High Courts and the Company Law Board was not unconstitutional. Nevertheless, the Madras High Court concluded that various provisions of Part 1B and 1C suffered from constitutional infirmities which had to be sufficiently amended to establish the NCLT and the NCLAT. The petitioner felt aggrieved that the establishment of the NCLT and the NCLAT was held constitutional, whereas the Union of India felt dissatisfied that provisions contained in Section 1B and 1C of the Companies Act 1956 were held as defective or unconstitutional. Hence, both the parties filed appeals in the Supreme Court against the judgment dated 30th of March 2004. The Honorable Supreme Court in Union of India versus R. Gandhi, President, Madras Bar Association, on May 11, 2010, upheld the legislative competence of Parliament to create the National Company Law Tribunal and the National Company Law Appellate Tribunal, but the particular structure of the NCLT and the NCLAT proposed by the 2002 Amendment Act was held to be unconstitutional. The government was required to make amendments to the 2002 Amendment Act, including but not limited to the selection of members, tenure of members, and qualification of the judicial and technical members of the tribunal before it could set up actual and functional tribunals. However, even after the passing of the Honorable Supreme Court's judgment in May 2010 with respect to the constitutional validity of the setting up of the NCLT and the NCLAT, the same could not be established. Subsequently, the Parliament of India notified the Companies Act 2013, which replaced the 1956 Act and included substantial provisions with respect to the establishment, powers, operations and jurisdiction of the NCLT and the NCLAT in line with necessary changes required by the Honorable Supreme Court in the May 2010 judgment. However, the corresponding provisions relating to the National Company Law Tribunal and the National Company Law Appellate Tribunal prescribed under the 2013 Act was again challenged by the Madras Bar Association with respect to inconsistency in the provisions of the 2013 Act with the directions of the Honorable Supreme Court in the previous judgment of May 2010. The issue has been finally decided by the Constitution Bench of the Apex Court on May 14, 2015 in Madras Bar Association versus Union of India and another, whereby the Apex Court held that the constitution of both the NCLT and the NCLAT is constitutionally valid, as has been held in the Supreme Court judgment of May 2010. The Apex Court rejected the contention of the petitioners and stated that the legislature has the power to enact a law which transfers the jurisdiction exercised by a court in regard to a specific issue to any tribunal set up for that specific purpose. The court also opined that all courts are tribunals and any tribunal to which the jurisdictional power is transferred should be a judicial tribunal. Therefore, the tribunals should be governed by members who are equal in capacity, status and rank with the members of a court. The tribunal should also have a secure tenure and independence. Thus, the Honorable Supreme Court paved the way for the constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal under the 2013 Act. Dear students, we shall now discuss the present position of the National Company Law Tribunal. The central government has constituted the National Company Law Tribunal under Section 408 of the Companies Act 2013 with effect from the 1st of June 2016. In the first phase, the Ministry of Corporate Affairs has set up 11 benches, one principal bench at New Delhi and 10 other benches at different locations. Subsequently, more benches have been set up and new members have joined. Dear students, now we address the question as to the requirement of NCLT and the NCLAT. That is, why do we require them? The constitution of the National Company Law Tribunal and the National Company Law Appellate Tribunal was a step towards improving the ease of doing business by bringing all aspects of company law matters under one roof. Some of the most important advantages are: Number 1, single window. The most important benefit that the tribunals will act as a single window for the settlement of all company law related disputes effectively. It shall avoid unnecessary multiplicity of proceedings before various authorities or courts. The second advantage is speedy process. The NCLT and the NCLAT are under a mandate to dispose of cases before them as expeditiously as possible. In this context, a time limit of 3 months has been provided to dispose of cases with an extension of 90 days for sufficient reasons to be recorded by the President or the Chairperson as the case may be. The speedy disposal of cases will save time, energy and money of the parties. The third advantage is reduction of the work of the High Court. The number of pending cases with the High Court is too high, and now the matters in respect to compromise, arrangement, amalgamations and winding up stand transferred to the National Company Law Tribunal. Accordingly, the NCLT and the NCLAT will reduce the work of the overburdened high courts. Hence, with the constitution of the NCLT and the NCLAT, it is hoped that the corporate world would be benefited and all the stakeholders would also stand to gain. Dear students, we now have a look at the composition of the NCLT. The NCLT is headed by the President and comprised of judicial members and technical members. The President shall be a person who is or has been a judge of the High Court for 5 years. A person shall not be qualified for appointment as a judicial member unless he is or has been a judge of the High Court or is or has been a district judge for at least 5 years or has at least 10 years been an advocate of a court. For the purposes of the last clause, in computing the period during which a person has been an advocate of a court, there shall be included any period during which the person has held judicial office or the office of a member of a tribunal or any post under the union or a state requiring special knowledge of law after he became an advocate. Dear students, now we shall discuss the qualifications for the technical members. A person shall not be qualified for appointment as a technical member unless he has, number one, at least 15 years been a member of the Indian Corporate Law Service or Indian Legal Service and has been holding the rank of a secretary or additional secretary to the government, or number two, is or has been in the practice as a chartered accountant for at least 15 years, or number three, is or has been in the practice as a cost accountant for at least 15 years, or number four, is or has been in the practice for at least 15 years, or is a person of proven ability, integrity and standing, having special knowledge and experience of not less than 15 years in industrial finance, industrial management, industrial reconstruction, investment and accountancy, or sixthly, is or has been for at least 5 years a presiding officer of a labour court, tribunal or national tribunal constituted under the Industrial Disputes Act of 1947. Dear students, we now come to the selection of the members of the tribunal. The President of the tribunal shall be appointed after consultation with the Chief Justice of India. The members of the tribunal shall be appointed on the recommendation of a selection committee consisting of, number one, the Chief Justice of India or his nominee as the chairperson. Number two, a senior judge of the Supreme Court or a Chief Justice of High Court as a member. Number three, Secretary in the Ministry of Corporate Affairs as a member. Number four, Secretary in the Ministry of Law and Justice as a member. Number five, Secretary in the Department of Financial Services in the Ministry of Finance, again as a member. The Secretary, Ministry of Corporate Affairs, shall be the convener of the selection committee. The selection committee shall determine its procedure for recommending persons under this subsection 2. No appointment of the members of the tribunal or of the appellate tribunal shall be invalid merely by reason of any vacancy or any defect in the constitution of the selection committee. Dear students, we now have a look at the term of office of the President, the Chairperson and other members. The President and every other member of the tribunal shall hold office for a term of 5 years from the date on which he enters upon his office, but shall be eligible for reappointment for another term of 5 years. A member of the tribunal shall hold office until he attains, in the case of President, the age of 67 years. In the case of any other member, the age of 65 years. Pertinently, a person who has not completed 50 years of age shall not be eligible for appointment as a member. Further, a member may retain his lien with his parent cadre or the ministry or department while holding office for a maximum period of 1 year. Dear students, we now have a look at the resignation of the members. The president, the chairperson or any member may, by notice in writing under his hand addressed to the central government, resign from his office. The president or the chairperson or the member shall continue to hold office for a period of 3 months from the date of receipt of such notice by the central government or until a person duly appointed as his successor enters upon his office or until the expiry of his term of office, whichever is the earliest. Dear students, we now have a look at the provisions relating to the removal of members. The central government may, after consultation with the Chief Justice of India, remove from office the president, the chairperson or any member who, number 1, has been adjudged as an insolvent. Number 2, has been convicted for an offence which in the opinion of the central government involves moral turpitude. Or number 3, has become physically or mentally incapable of acting as such president, the chairperson or member. Or number 4, has acquired such financial or other interest as is likely to affect prejudicially his functions as such president, the chairperson or member. Or number 5, has so abused his position as to render his continuous office prejudicial to the public interest. Provided that the president, the chairperson or the member shall not be removed on any of the grounds specified in clauses 2 to 5 without giving him a reasonable opportunity of being heard. Importantly, the president, the chairperson or the member shall be removed from his office on the ground of proved misbehavior or incapacity in the manner which we shall discuss as: number 1, the president, the chairperson or the member has been informed of the charges against him and given a reasonable opportunity of being heard. Number 2, the central government refers the matter to a judge of the Supreme Court nominated by the Chief Justice of India. Number 3, an enquiry has been made by such judge of the Supreme Court. Number 4, the central government passes orders on receipt of the report of the judge of the Supreme Court to whom such reference has been made. Dear students, we shall now discuss the jurisdiction of the National Company Law Tribunal. The tribunal has jurisdiction on the matters under the Companies Act 2013, which include: number 1, cancellation or variation of the rights of the shareholders. Number 2, redemption of preference shares. Number 3, transfer and transmission of shares. Number 4, rectification of the register of members. Number 5, reduction of share capital. Number 6, petition of debenture trustees. Number 7, public deposits. Number 8, repayment of deposits. Number 9, power to call annual general meeting or meeting of the members. Number 10, disqualification of a director. Number 11, protection of employees during investigation. Number 12, compromise or arrangement with the creditors. Number 13, merger and amalgamation. Number 14, oppression and mismanagement. Number 15, removal of name of a company from the register of companies. Number 16, revival and rehabilitation of sick companies. Number 17, winding up. Number 18, fraudulent preference. Number 19, deposit of monies in the scheduled bank by a company liquidator. Dear students, we shall now have a look at the procedure which has to be followed by the National Company Law Tribunal and the National Company Law Appellate Tribunal. The tribunal and the appellate tribunal shall not, while disposing of any proceeding pending before it, be bound by the procedure laid down in the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. Subject to other provisions of the Companies Act and any rules made thereunder, the tribunal and the appellate tribunal shall have the power to regulate their own procedure. The tribunal and the appellate tribunal shall have, for the purposes of discharging their functions under the Companies Act, the same powers as are vested in a civil court under the Code of Civil Procedure 1908. While trying a suit in respect of certain matters. A. Summoning and enforcing the attendance of any person and examining him on oath. B. Requiring the discovery and production of documents. C. Receiving evidence on affidavits. D. Subject to the provisions of Section 123 and 124 of the Evidence Act, requisitioning any public record or document or a copy of such record or document from any office. E. Issuing commissions for the examination of witnesses or documents. F. Dismissing a representation for default or deciding it ex parte. G. Setting aside any order of dismissal of any representation for default or any order passed by it ex parte. And H. Any other matter which may be prescribed. We also have to remember any order made by the tribunal or the appellate tribunal may be enforced by that tribunal in the same manner as if it were a decree made by a court in a suit pending therein. It shall be lawful for the tribunal or the appellate tribunal to send for execution of its orders to the court within the local limits of whose jurisdiction A. In the case of an order against a company, the registered office of the company is situated, or B. In case of an order against any other person, the person concerned voluntarily resides or carries on business or personally works for gain. All proceedings before the tribunal or the appellate tribunal shall be deemed to be judicial proceedings within the meaning of Section 193 and 228 and for the purposes of Section 196 of the Indian Penal Code, and the tribunal and the appellate tribunal shall be deemed to be civil court for the purposes of Section 195 and Chapter 26 of the Code of Criminal Procedure. Dear students, we shall now have a look at the appeals from the order of the National Company Law Tribunal. Any person aggrieved by an order of the National Company Law Tribunal may prefer an appeal to the National Company Law Appellate Tribunal. No appeal shall lie to the appellate tribunal from an order made by the tribunal with the consent of the parties. Every appeal under the subsection 1 shall be filed within a period of 45 days from the date on which a copy of the order of the tribunal is made available to the person aggrieved and shall be in such form and accompanied by such fees as may be prescribed. Provided that the appellate tribunal may entertain an appeal after the expiry of the said period of 45 days from the date aforesaid, but within a further period not exceeding 45 days, if it is satisfied that the appellant was prevented by a sufficient cause from filing the appeal within that period. On the receipt of an appeal under subsection 1, the appellate tribunal shall, after giving the parties to the appeal a reasonable opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against. The appellate tribunal shall send a copy of every order made by it to the tribunal and the parties to the appeal. Dear students, this is all with regard to today's lecture on the National Company Law Tribunal and various aspects relating to its functioning. Hope you enjoyed the lecture. Stay blessed.